before they
Don't get brazen with me.
And he had nothing in his hands, and he was shot twice and killed.
Courtrooms can be a very dangerous place for a corrupt officer, and these pigs were completely owned, particularly the officer in the last case who even shocked me. In 2016, a pretrial court was set up to determine Officer Osvaldo Villarreal's qualified immunity after he shot and killed Benny Herrera in 2011. Herrera's family filed a lawsuit leading to this trial.
This is a tragic case, there's no question about that. But Officer Villarreal was required to make a split-second life and death decision.
What required him to do that? It doesn't look to me as though he was the initiator.
The fact that Mr. Herrera, first of all, he had been acting erratically before the shots were fired. From a place of relative safety on the shoulder of the road into the roadway, he was skipping
backwards. But if we're talking about
and
Officer Villarreal, how much did he know about the prior behavior?
he saw all of that.
I have to say what you're saying is inconsistent with what I saw on his own camera. That is to say, the point at which he began to get close enough to see anything. Some of that earlier stuff was on the other camera, but not on his.
The tragic incident occurred after Officer Villarreal was called to the scene, where he confronted the deceased. The corrupt cop asked him to take his hands out of his pockets, and just a mere second after that, he shot him twice.
His camera was turned on, but
his camera was turned on well before he got to the scene.
He testified in deposition that he saw Mr. Herrera on the side of the road, and then he saw.
Well, he can testify to what he wants to testify to, but I want to tell you what I saw on his own camera tells me that the early part of this he did not see, could not see. That was his intention, you say?
That was his intention, and that's in his deposition.
Again, I'm relying on what's on the videotape, and now this is in Officer Villarreal's car. I hear him say, "Take your hand out of your pocket," and I hear the gunshot almost simultaneously.
Exactly.
They cannot be separated by more than a second.
And that's exactly the time period when Officer Villarreal had to make his decision.
Benny Herrera was unarmed and posed no threat to the officer. Shockingly, the officer was also cleared at first.
Before, he was asked in deposition, well, what were you going to do when you asked him to take his hand out of his pocket? Well, I was going to put him in a control position. That's what he intended to do.
So he's taking his hand out of his pocket.
Yes.
And as he's obeying the officer's command, he gets shot.
But it's the way that he does it, Your Honor. He didn't just stand still and take his hand calmly out of his pocket. Is he doing this peacefully? Or does he have something in his hand that could be a threat to me and is my life in danger?
Well, right.
He had a fraction of a second to make that
Well, don't we
decision.
have to view this in the light most favorable to the plaintiff here? I mean, and so if we do what you just said right now, offer two possibilities.
The judges had seen the body cam footage and believed that the officer should at least be tried for this act.
Here, Mr. Herrera was arguably complying with Officer Villarreal's order to remove his hand from his pocket at the time that he was shot. How is it that we determine that we should grant qualified immunity?
Because qualified immunity allows for police officers to make mistakes. It allows for the possibility that officers will make mistakes in judgment, and that's exactly what happened here. Officer Villarreal had a choice to make. Do I wait and see whether there's something in the hand that could kill me, or do I shoot? And he made the decision to fire. We know with the benefit of hindsight, obviously, that was wrong.
Is it significant that is it Miali?
If the perpetrator hadn't been an officer, he likely would have been held accountable and labeled a murderer. There are serious flaws in the lawyer's arguments.
He had a better vantage point possibly than Mr. Villarreal.
He actually didn't, for these reasons. Officer Miali was facing, from his point of view, he saw Mr. Herrera's back, not Mr. Herrera's front. So he couldn't see, and he testified in his deposition that he couldn't see Mr. Herrera's hands as they were coming out of his pocket. He also, if he had fired, he would have fired toward an apartment complex. Officer Villarreal fired toward a block wall.
I guess the issue I'm having here is that these are arguments, in my mind, for a jury. That certainly you can lay these out, but we're at a very limited scope here. This is not jury redo. We have to determine based on the facts as alleged by the plaintiff. And right. they're gonna say, no, he simply had his hand in his pocket and these officers were coming up on him really strong. They created the tension. They rose the adrenaline, not him. You have to lay out take their facts, not the facts as you want. You got to stick with their facts and explain why under their facts you win as a matter of law.
I agree, Your Honor.
Every single judge on the panel seemed to be on Herrera's side, and it appeared that the officer was about to lose his qualified immunity shortly.
As long as the historic facts are undisputed, the question of whether or not Officer Villarreal's actions were reasonable is a question of law. It's not a question that you give to a jury, because we don't want juries second-guessing the very, very difficult life and death decisions that officers have to make.
I agree, but at this stage, again, this is not an argument to a jury. For us to even have jurisdiction over this case, those facts, you're saying that as a matter of law, Officer the shooting here was legal.
Yes, it was objectively reasonable. Well, not just those facts. Officer Villarreal knew that Mr. Herrera was a suspect in a domestic violence incident.
Okay.
He knew that he had a gang affiliation, that he was on parole, that he had a warrant out for his arrest. All of those things factor into
on parole. I don't remember on parole. They said
on parole, yes, and there was a warrant out for his arrest.
What do we know about what Officer Villarreal knew with respect to whether he was armed?
We know that dispatch told Officer Villarreal and Officer Miali that Mr. Herrera was not known to be armed.
The judges asked the right questions, and the attorney was quickly running out of arguments. Shockingly, she thought this was a reasonable mistake.
also the suspect had refused to put up his hands, had threatened the officers, and an officer believed that she saw something in the suspect's hand, saw him move his arm, and was worried he was going to shoot her. But yet we affirmed the denial of qualified immunity in part because the suspect had not brandished a weapon or spoken of a weapon.
I do recall that case, Your Honor.
But that wasn't enough for the attorney, and the judge was about to make her look like even more of a clown.
Domestic violence incident was over.
Yes, and there.
So, I mean, how does that strengthen your case? I mean, that was, if you're arguing that it was an ongoing domestic violence, so.
It wasn't an ongoing domestic violence incident. And it's easy for us to sit in hindsight and say, well, Mr. Herrera didn't have a gun. Mr. Herrera didn't really pose any
I don't think
threat.
anyone here said that one time.
No,
I think what we're focusing on, again, the narrow standard we have to deal with here, that's what we're dealing with. This is not a jury trial. This is not summary judgment. It's a very limited thing. No one here is raised about the fact he didn't have a gun.
I understand. The trial court did.
The judges then called for the plaintiff's attorney to take the stand and explain why the officer's qualified immunity needs to be removed.
But I think there's no question that he had his hand in his pocket.
Well, and both officers said it looked like he had something heavy in his pocket. And then just before Mr. Villarreal opened fire, Mr. Herrera rapidly removed his hand and moved quickly, it seemed like, toward the officer's car. Why isn't that enough?
Well, because sticking on the undisputed facts, the officers had no information that any weapon was involved in a crime. They were specifically told he was not known to carry weapons.
The attorney came well prepared and brilliantly answered, completely dismantling the officer's narrative.
Opposing counsel that he's entitled to make a reasonable mistake.
Well, if that was the standard alone, then every single shooting case, the defense would argue that an officer is entitled to a reasonable mistake, and that's the end of the analysis. I think for purposes here, one has to look at the facts supporting the plaintiff's version, and he had nothing in his hands, and he was shot twice and killed. We specifically asked the officers about their training, and they conceded, which is included in the cites in our brief, that deadly force is a last resort, only to be used in the direst of circumstances, only when no other reasonable measures are available.
The defense attorney would once again plead to the judges to withhold the qualified immunity, but things were looking quite tough for the corrupt cop.
The jury does not get to decide qualified immunity?
Qualified immunity is a question of law for the court.
You mean, so depending on, the jury has to decide whether or not there's been a constitutional violation, and at trial the jury cannot say to your officer, you're off the hook because you have qualified immunity? That can't be right.
Predicate facts.
I understand that, but I think I'm arguing on your point, if we send this back, I don't think you want to say qualified immunity is no longer available to you at trial.
Absolutely not.
Well, I think that's what you just said. That's why I'm speaking up.
That was not my intention at all.
Soon, the judges ended the court not before owning the defense attorney one last time.
If everything goes bad for your client, that is to say, if we send it back, if the jury says no qualified immunity, and if the jury comes in with an award of some amount of damages, will your client pay those damages out of his own pocket, or will it be paid by his employer?
It should be 99.9% of the times it's paid by the employer. I don't see why it would be different.
Well, by statute, California statute says it's paid by the employer unless they're punitives.
Yes,
isn't that right?
That was what I was going to say.
So that doesn't say 99%, it says 100.
Well, I was going to say, unless they're
punitives.
If there were punitive damages, the city would have the option of deciding whether to pay those punitives. My understanding is that
Shortly after, the judges issued a written statement abolishing the officer's qualified immunity and calling for a trial, alleging that he had used unlawful deadly force. The city soon settled with Herrera's family for $1.4 million, and Officer Villarreal was fired. Next up, we have another courtroom drama, and this time it's a lawyer who gets completely owned.
And the court left the door open.
For me, not for you.
For the defense
Don't
testimony.
get brazen with me.
During the Kyle Rittenhouse intentional homicide trial, the lead prosecutor, Thomas Binger, made a huge mistake of ignoring previous rulings, leading to an angry defense attorney and judge.
I'm going to ask you to go into the library again for a moment, please. Please don't talk about the case.
Binger is either forgetting the court's rulings or attempting to provoke a mistrial in this matter. He knows he can't go into this, and he's asking the questions. I asked the court to strongly admonish him, and the next time it happens, I'll be asking for a mistrial with prejudice.
First of all, Your Honor, this was the subject of a motion. I'm well aware of that. And the court left the door open.
For me, not for you.
Attorney Binger thought he could do what he wished, but he was about to be proven wrong by Judge Schrader.
My understanding of
You should have come and asked for reconsideration. You did on the one motion, and in fact, I granted your motion for reconsideration.
That was not
Excuse
our
me,
motion.
I held it open with a bias towards denial. Why would you think that that made it okay for you, without any advance notice, to bring this matter before the jury? I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that, and it gives, well, I'll leave it at that.
The attorney was humbled and exposed in front of everyone, and the worst was yet to come.
He was using it in a manner to try and protect property.
No, he wasn't.
Your Honor, with all due respect,
I'm not going to rehash the motion. That's absolutely untrue. No. Your argument's of record. My comments are of record, and why I ruled as I did is of record. There's nothing that I heard in this trial to suggest anything's changed, even if you're correct in your assumption that you know more than I did at the time. Why you would think that you could go into it without any advance notice to the court, I don't understand that. And as the defense is pointing out, you're an experienced trial lawyer, and this should not have been gone into.
Well, not only the judge, but the defense was extremely shocked to hear Binger's lies.
just testified this morning that he agreed with that person in the yellow pants, that he pointed the gun at him. He said, I was joking when I said that to the guy in the yellow pants, but he said, he's acknowledged that he told the person in the yellow pants, yeah, you're right. I did point a gun at you when you were sitting on a car.
He said, I did. That's what he
Exactly.
testified. There's a lot of difference between commenting about something when you haven't got a gun and threatening someone when you do.
You know, it's interesting, Your Honor, because the entire defense theory in this case is Joseph Rosenbaum, who was unarmed.
I want you to tell me what the defense theory of the case is. May I
respond to what you just said, Your Honor? I'd like to respond to what you just said.
This was no way to speak to a judge, and the attorney definitely needed to be held accountable.
I'm going to interrupt you now because you're talking about his beliefs. I think that's what they call...
His statements do, Your Honor. Because he just said, can't use deadly force, can't threaten to use deadly force to protect property. So now I'm impeaching him on that.
Your Honor, the court has seen no reason to change its ruling. And just so this record is clear, in spite of the lengthy statement by Mr. Binger, before we started today, the court specifically stated in Mr. Binger's presence, there's been nothing to have me change any of my rulings. If you're going to go into something that's been excluded in a pretrial order, you better ask the court, you better get permission. This is ridiculous.
It wasn't excluded, Your Honor.
You know why it was excluded in the first place? Because it was propensity evidence.
If that wasn't enough, Judge Schrader was about to completely own the attorney.
His attitude is he wants to shoot people. Now, I've admitted that kind of evidence in other trials when it's been appropriate. I didn't admit it in this case because, to me, what I've heard in this trial, and by the way, Mr. Richards absolutely correctly points out that just hours ago, I said I had heard nothing in this trial to change any of my rulings. So why?
Testimony, Your Honor.
Pardon me?
That was before the defense testimony.
Don't get brazen with me. You knew very well. You know very well that an attorney can't go into these types of areas when the judge has already ruled without asking outside the presence of the jury to do so. So don't give me that. That's number one. Wigmore and evidence. Judge Weinstein, Colonel McCormick. It's the prior act has to bear the signature of the accused, or it has to be so similar as to suggest it's a common plan or something like that.
Judge Schrader made sure to tell the attorney who was the boss inside the courtroom and shortly concluded his speech before calling the jury back in.
When you were I said you were over the line, close to or over the line on commenting on the defendant's pretrial silence, which is a well-known rule. I'm astonished that that would have been an issue. So I don't want to have another issue as long as this case continues. Is that clear?
It is.
Thank you.
After a complete humiliation, the prosecutor finally learned why it wasn't a great idea to go against the judge and his rulings. Coming back to cops, this corrupt pig was rightfully sentenced to prison, and you'll be stunned to see his reaction.
Defendant Aaron York deemed guilty beyond a reasonable doubt of the offense of manslaughter. Assess his punishment at confinement in the Texas Department of Criminal Justice for 11 years, 10 months, 12 days.
Former Officer Aaron Dean, who fatally shot an innocent woman through her bedroom window, is about to be charged with the heinous murder.
Y'all did fabulous when we did the guilt-innocence verdict, okay? Same rules apply. I don't know what this verdict is. Can't have any emotions, all right? Let's bring him in. Verdict reads, we the jury, having found the defendant Aaron York deemed guilty beyond a reasonable doubt of the offense of manslaughter, assess his punishment at confinement in the Texas Department of Criminal Justice for 11 years, 10 months, 12 days. They do not assess a fine. And it is signed by the presiding juror. You may be seated. Thank you very much.
The killer cop sat across from the judge with no remorse on his face, as if he had no guilt for what he did.
Juror number 1, is this your verdict?
Yes, Your Honor.
Juror number 3, is this your verdict?
Yes, Your Honor.
Juror number 4, is this your verdict?
Yes, Your Honor.
Juror number 6, is this your verdict?
Yes, Your Honor.
Juror number 9, is this your verdict? Juror number 37, is this your verdict?
Yes, Your Honor.
Juror number 38, is this your verdict?
Yes, Your Honor.
Your verdict will be received and filed. Thank you very much. Mr. Gill, Mr. Brissett, is there any legal reason why sentence should not be pronounced?
No legal reason.
Mr. Dean, it's the jury having found you guilty of the offense of manslaughter and assessed this punishment. It's the order of the court you be remanded to the custody of the sheriff, be delivered to the director of the Texas Department of Criminal Justice to serve your sentence as required by law. You will receive credit for all the time that you have served in custody on this case from the date of your original arrest up until today, which would be the date of sentence.
Dean was ultimately convicted of manslaughter instead of murder and was sentenced to 11 years in prison.
If you are indigent and cannot afford a lawyer, I would conduct an indigency hearing to determine if you are indigent. And if you are indigent, I would appoint a lawyer to represent you on appeal and provide you a record of this appeal of this trial at no cost. Is there an allocution?
There is.
You may be seated. Thank you very much.
The officer is currently in jail, and some people believe the punishment should have been much more. Let me know your comments below. Well, that also brings us to the end of this video. Today we saw corrupt cops swiftly owned and humbled in courtrooms. These judges delivered lessons they'll never forget, setting an example for officers to ensure they never cross the boundaries of the law. If you agree with me, please consider showing your support by liking this video, and also make sure to subscribe to stay informed about future cases like these. Also, if you enjoyed this video, check out the next video here.